pleased to be here to discuss the work of the Office of the Inspector General, particularly in counterterrorism and counterintelligence areas over the last 11 years. OIGs are not widely known institutions throughout government, but they can have a tremendous impact on the agencies that they oversee. There is an IG in every federal agency in the United States. There's 69 of them. Some of them in the larger agencies are appointed by the President and confirmed by the Senate, and the smaller agencies by the agency head. Our mission of the IG is to detect and deter waste, fraud, and abuse in the agency and promote economy and efficiency in agency operations. You have jurisdiction within your agency to look at the operations of that agency and to promote its effectiveness and efficiency. In the Department of Justice, we had, in the Office of the Inspector General, we had 450 auditors, lawyers, investigators, program analysts to oversee the work of the Department of Justice. Now I can see some of you thinking, wow, that's a lot of people to oversee the Department of Justice. But the fact is the Department of Justice is a huge operation, it's a widespread operation, and it needs effective oversight. In fact, take a guess, how big is the Department of Justice? How many employees does the Department of Justice have? Anybody want to guess? 10,000. 10,000. A lot more.
200,000.
A little bit less. 110,000 employees and a $29 billion budget. So with that kind of an operation, you need oversight, you need an effective agency with people in it to oversee the Department of Justice. And it is a great job. I was nominated by the President in 2000 and confirmed by the Senate. And let me tell you a brief story about how I learned I was confirmed by the United States Senate to be the Inspector General of the Department of Justice. I was in the office for 5 years. I was the head of the Special Investigations Unit. When the prior Inspector General left, I was nominated by President Clinton to be the Inspector General in 2000. I had a hearing before the Senate Judiciary Committee, and I was voted out unanimously. I was a nonpartisan person. I wasn't tied to either side of the political aisle, and I was expecting to get a vote on the Senate floor. And in fact, they told me I was going to be up for a vote, for a unanimous consent vote, but only when the Senate went out of session that year. But as you remember, 2000 was an election year, Bush versus Gore, and the Senate did not go out that year. They just stayed in session as the election campaign went on, and then there was the election, and then there was the contest period after the election. And then finally, in about December, the Supreme Court ruled we were going to have President Bush, and I thought, well, there's no way that anybody would be confirmed at this point. It was nice while it lasted, and I'd have to try and find another job. The last day of the Senate, when it was about to go out of session, I got a call from the Department of Justice Office of Legislative Affairs person, and she said, Glenn, they're going to confirm a few people on the Senate floor today, and I think you may be one of them. And I said to her, wow, that's really terrific. Are you sure it's going to happen? She said, I'm not sure, but I think it's going to happen. I said, how do I find out if it happens? She said, well, the best way to find out is do this. Call this number, it's the clerk of the Senate, and you were the 578th nominee, presidential nominee this year. Ask the clerk of the Senate what happened to 578. I said, really? That's how you find out if you've been confirmed by the United States Senate? They say, what happened to 578? She said, yeah, that's the best way to do it. Call this number when you get home. I said, okay. So I went, I packed up, I went home, I told my wife, she was all excited. She said, okay, call. We want to find out. So I said, okay. So I call this number, and somebody picks up the phone and says, hello, what can I do for you? I said, excuse me, could you tell me what happened to 578? And he said, oh, hold on. And he puts me on hold. And I'm on hold for 10 minutes. And then finally he gets back on the phone. He says, what'd you want again? I said, could you tell me what happened to 578? And he said, oh, all right. And he was obviously very busy, and you could hear, and so you could hear him shuffling papers. And then he says, by the way, who is this? Are you 578? And I said, yes, I'm 578. And he said, well, congratulations, Mr. Fine. You've been confirmed by the United States Senate as the Inspector General of the United States Department of Justice. Merry Christmas. So that's how I learned I was confirmed in this august position of the Inspector General of the United States Department of Justice. And it hasn't always been a Merry Christmas being the Inspector General. I was the Inspector General from 2000 to 2011. And in some ways, it was like straddling a barbed wire fence. That's what they say about Inspector Generals, because you report both to the head of your agency, the Attorney General, and Congress. And it's designed not to make you popular when you're overseeing your agency. inside your agency. You are viewed as sometimes being too hard on the agency, by others as being too soft on the agency. Sometimes you're viewed as having a witch hunt, other times you're viewed as conducting a whitewash. Sometimes you're viewed as being an attack dog, other times you're viewed as being a lapdog. Sometimes all of this is in the same case. It's designed not to make you popular in the Department of Justice, but that's not your role, to be popular in the Department of Justice. I'll tell one more story. After I became the Inspector General, I went up to the Senate and briefed the Senator about one of the reports that we had just issued, what was in it, and the implications of it. There was a senator who was very interested in IGs, and he took the briefing. And afterwards he said, let me tell you what I think about the most important thing about IGs. You're not going to be liked. There are going to be times when you do things that I don't like. There are going to be times when you do things that the Attorney General doesn't like. You're just not going to be liked. Nobody's going to like you. You can't worry about being liked, so don't think about it. Nobody is going to like you. Nobody's going to like you. And I was up there with my deputy, a great guy by the name of Paul Martin, who'd been with me for a long time. And he was listening to the senator, kept saying to me, no one's going to like you, no one's going to like you. And finally he said to the senator, don't worry, Senator, even I don't like him. The senator laughed, and that was the end of the meeting. But there was a point to it, and that is you're not designed, as the IG, you're not going to be liked. It's not a popularity contest. You're there to be tough but fair with the agency. And I'd like to talk briefly about our role in the Department of Justice and the role we played, particularly with regard to counterterrorism and counterintelligence matters over the years that I was the Inspector General. So there are basically three main topics I'd like to talk about today, and I want to talk for maybe half an hour or so, and then leave plenty of time for discussion, moderated by Scott Horton, and then question and answers. But briefly, three topics. I want to lay out the structure and the authorities of the Office of the Inspector General, how we operate it. I want to talk about several representative reviews we did, some cases, some important cases, some of which FISA mentioned. Then I want to talk about the challenges facing an Office of the Inspector General in conducting this kind of oversight, these kind of important reviews. So first, the authorities of the Department of Justice Office of the Inspector General. We had wide-ranging authorities in our role as overseer of the Department of Justice. For example, we had access to all records of the Department of Justice. We had subpoena power to subpoena documents outside the Department of Justice if we needed them. We had the authority to compel interviews of Department of Justice employees, to take statements under oath, to execute search warrants and arrest warrants. We were independent, so we could hire our own people, decide what investigations or audits or program reviews to do, and we couldn't be, except in very narrow circumstances, could the Attorney General tell us that we couldn't conduct that investigation or complete that investigation. We had authority throughout the entire Justice Department, and the Department, as I mentioned, the Department of Justice is huge. It includes the FBI, the Drug Enforcement Administration, the U.S. Marshals Service, the Federal Bureau of Prisons, the Bureau of Alcohol, Tobacco, Firearms, and Explosives, U.S. Attorney's Offices, Maine Justice. We had authority all throughout the Department of Justice, with one narrow exception, and that is there was an entity in the Department of Justice called the Office of Professional Responsibility that had oversight over attorneys in the exercise of their legal duties. That was their responsibility. Other than that, we had authority over the entire Justice Department. And we can conduct any investigation we want and take it wherever it led. So how did we operate? We had two sides of our operation. We had an audit and program review side, and we had an investigative side. The audit and program review looked at the programs of the department to see whether they were operating effectively and efficiently. We did computer security audits. We did financial statement audits. We did grant and contract audits. We did program reviews. Some of the program reviews were very sensitive and very important. For example, our auditors did a review of the FBI's foreign language translation program, whether they were translating all the materials they were collecting in foreign languages or whether they were languishing untranslated in FBI files. We found that in many cases they were. We did a review of the FBI information technology upgrade and whether they were effectively upgrading their information technology so they could assimilate all the vast amounts of information they had. We did a review of the FBI's terrorist watch list nomination process to make sure that people were being put on the watch list who should be there, but who also people taken off on the watch list who shouldn't be on the watch list. We did an audit of the Department of Justice's preparation to respond to a weapons of mass destruction attack, coordination of explosives investigations between the FBI and the ATF, a whole series of reviews reviews by our auditors of the programs and operations of the Department of Justice. And one of our prime principles was to make those reviews public, publish the results of our reviews. So we gave the department a chance to comment on the reviews before they were public, but when they commented, we would then make their comments public as well. And we thought it was very important to make sure that the public had access to that information. We made recommendations to the department in those reviews, not only pointing out where things went wrong, but also how things could be improved, where things could be done better. And I think that was a critical aspect of those reports. So that was our program review and audit side. We also had an investigative side. And our investigators were like FBI agents. They were gun-carrying 1811 investigators who can do investigations of criminal and administrative misconduct by Department of Justice employees or programs. And we were the investigators and would take it to the U.S. Attorney's Office if there was a criminal misconduct involved. If there was administrative misconduct, we would give a report to the agency to enact disciplinary actions as a result. We had about 150, like I say, gun-carrying law enforcement agents with full investigative authority for a wide range of cases. And if an entity as big as the Department of Justice, with as many employees as the Department of Justice had, there would be something that would be going wrong at some point. It's just by the size of the organization, it was bound to happen. So we would do investigations of theft, conflicts of interest, embezzlement, introduction of contraband into prisons, sexual abuse in prison. I'll tell you a story about it. And it was dangerous work. When you were investigating law enforcement agents, you never know what can happen. And in fact, we had a tragedy occur to one of our agents. We had investigated a ring of prison guards who were sexually abusing female inmates in a prison in Tallahassee. And they were abusing them and threatening them with retaliation if they ever came forward. But we did find out about it, and we investigated it, and along with the U.S. Attorney in Florida, we indicted 5 correctional officers for sexual abuse of female inmates. We decided the best place to arrest them was in the prison. We wanted to be safer than going to each of their homes to arrest them when they were off duty. So we had a team of agents go to the prison to arrest this ring of indicted prison guards, and the first one was arrested without incident. And the second one, when we went to arrest him, he had a gym bag. He was holding a gym bag. And when we went to arrest him, he pulled a gun out of the gym bag, which he wasn't allowed to have in the prison, but he had it. And he started firing. He shot and hit a prison lieutenant, and he shot and missed a female agent. And then he shot and hit one of our agents, and our agent fell down. And then when he was going to shoot more agents, the agent who had been hit leaned back up and returned fire and shot and killed a prison guard. And then our agent fell back down and died. So it was, he was a hero. His name is Buddy Sentner. I talk about him in most speeches I give because it is both dangerous work and important work and heroic work, what we do. Not only the investigators, but all throughout the Department of Justice Office and Inspector General. So that's the investigative side. We also have what we call our Special Investigations Unit. It's a unit of combining the talents of lawyers, auditors, program analysts to do the special reviews that you've heard about, part of the ones that FISA mentioned and the ones that I'll mention. And these are not simply program reviews or investigations of individual misconduct, but a combination of all of that. And we'll take the investigation wherever it led. And this unit, the Special Investigations Unit, handled many high-profile investigations. And I'd like to talk about a few of them with you before talking about the challenges of the work that we did. The first one I'd like to talk about is the review that we did of Robert Hansen, the most damaging spy in FBI history. And when he was caught in 2001, people wondered, well, how was it possible that he could be a spy for the FBI, within the FBI for over 2 decades without being caught? And the initial story that was given was that he was so masterful. He was a master spy, he used master tradecraft, it was hard for the FBI to catch him. We were asked to do a review of that and found out that none of that was true. That he was both lax, irresponsible, and reckless in his spying. And the problem was that the FBI had a very lax internal security program and had the belief that the FBI was not penetrated and could not be penetrated. And they relied on trust internal security program. So things that he would do, that Robert Hansen would do, and that did not even get the attention of the FBI's internal security program. He would do things like hack into the computer system and get into the hard drives of other agents, even counterintelligence and counterterrorism agents. And when he was caught doing that, he said, well, I was just trying to do that to expose the weaknesses of the FBI system. And they accepted that explanation. And then he did it again. And he put on password hacker program on his computer to hack into other programs. And when he was caught, he said, well, I needed access to a color printer, and the administrator wasn't there, and so therefore I needed to get access to the color printer. And they accepted that. And then he disclosed information, sensitive information, to another country's intelligence service, which he shouldn't have done. And instead of taking action against him, they sent him to the Department of State, where he was not supervised, where he was basically left alone to watch videos, to serve, to visit his friends, and to continue his spying without any oversight at the FBI. He escaped detection not because he was such a master spy, but because the FBI had a terrible internal security program. He even did things like, when he got the money from spying from the KGB, he would deposit it into a bank account in his own name a few blocks from the FBI. He would do things like use the FBI's own phones for getting access to his handlers from the KGB. It was really quite incredible what we found. And what we did was we made recommendations to the FBI to improve their internal security program. He never had a background investigation. Well, he had one background investigation in 25 years. He never had a polygraph. He never had to make a financial disclosure. It was a terrible system. We made recommendations to the FBI, and they accepted them and improved their program. And that's, in my view, one of the benefits of as I mentioned before, of the Department of Justice Office of the Inspector General. We look not only what went wrong, but we make recommendations for improvement, and that's one of the critical things that we do. Another report, what the FBI witnessed at Guantanamo. At Guantanamo, at Abu Ghraib, and also in Afghanistan. And to its credit, the FBI agents were instructed to comply with existing FBI policies no matter where they were located, with the exception of not providing Miranda warnings, which were not necessary to be given in those settings. But FBI policies did not address what the FBI should do when they witnessed other agencies exhibiting abusive tactics towards detainees. And we surveyed FBI agents, and they saw many such abusive tactics, ranging from sleep deprivation in an effort to lessen the detainees' resistance, to questioning combined with bright lights, loud music, extreme temperatures. Some of them were short shackled in very uncomfortable positions for long periods of time. Occasionally they witnessed growling dogs or interrogating trying to provoke a response based upon sexually suggestive actions towards the detainee. One detainee was head wrapped in duct tape. All sorts of abusive tactics that the FBI would not countenance. They did make reports of this, but because these detainees were not in FBI custody, they were not. The reports were not really didn't have much of an effect on the other agencies' interrogation policies. We did find that the FBI was not giving its agents clear guidance on what to do when they saw these abusive tactics and whether they could even interview the detainees after the abusive tactics had taken place. But while the FBI could have provided clearer policies, we did credit them for the professional actions in this very difficult environment. So we don't always completely critique or criticize the FBI, but sometimes we pointed out where they should be credited with professional conduct. Another program that we reviewed, the President's Surveillance Program. Some people call it the Warrantless Wiretapping Program or the Terrorist Surveillance Program. This is a program where the National Security Agency's authority was expanded to allow it to conduct electronic surveillance within the United States without an order from the FISA court when certain factual conditions and legal standards were met. And what was publicly disclosed was the communications into and out of the United States where there was a reasonable basis to believe that one party of the communication was a member of Al-Qaeda or a member of a related terrorist organization. We did a review of this program along with the inspectors general from other intelligence agencies, the DOD, the CIA, NSA, and we focused on what the Department of Justice did. And what we found there was that the legal basis for this program was supported and drafted by one official in the Department of Justice, one line-level official in the Office of Legal Counsel named John Yu, and not even his supervisor, the Assistant Attorney General for OLC, was read into the program or reviewed his legal support for this very significant program. And in fact, successors to the Assistant Attorney General in OLC after this memo identified deficiencies and weaknesses in the memorandum, both factual and legal, and which Yu's memo did not address, and which undermined the rationale for this program. And as you may recall, this led to the famous confrontation in the hospital room between Attorney General Ashcroft and, at the time, White House Counsel Gonzalez and and White House Chief of Staff Andy Card, where they went to the hospital room in an effort to get further authorization for the program. And John Ashcroft, on his sickbed, basically leaned up and said, "I'm not going to authorize the program. That really doesn't matter because I'm not the acting Attorney General at the time. Jim Comey was," and there was this very, very famous confrontation at the hospital scene, at the hospital. We reviewed that, and we looked at that, and we thought that part of the problem here was that only one OLC attorney, without adequate supervision, without adequate peer review, had supported the program when this was in contradiction to the normal process in the Office of Legal Counsel. We considered it extraordinary and inappropriate, and we suggested it not happen again. It was a very, very interesting review. We made this report public, and it's often difficult to make some of our reports public because they contain a lot of classified information in it. But what we try and do, and we had a very lengthy report, 500-page classified report, but what we tried to do was make a summary of it available in an unclassified way so that people could read and understand what was happening. We thought that was very important. We were required to do it by statute, but we were doing it in this case, but we do it in almost every case, try and make a report available to the public, because in the end, it's the public who has a right to know about the operations of its government and the Department of Justice. Two more reviews, or actually 3 more reviews I'd like to talk about. One, compliance with the Attorney General guidelines on confidential informants. There are Attorney General guidelines for the FBI on what they must do when they use a confidential informant. They're designed to ensure that the confidential informants are properly vetted for suitability, or warned about the limits of their authority, what they can do as a confidential informant, and if they are to engage in illegal conduct as part of their confidential informant activities, they must do it under very close scrutiny and under strict circumstances, and they must be told about that, and it must be handled in conjunction with the prosecutors, and that when the use for the confidential informant is over, that they are deactivated, and the deactivation is properly reported. Again, we found significant problems with the FBI's compliance with these guidelines, and that we found 1 or more guidelines violations in 87% of the reviews we did. 87% of the reviews we did, which is a huge number. We found they did not contain adequate suitability reviews, did not contain documentation about the instructions that were given to confidential informants, that improper authorization to commit otherwise illegal activities was sometimes given without adequate documentation or authority, and that often there was no even documentation to show that the confidential informant was deactivated. It was a stunning result that we found when we looked at these files, and the FBI, to its credit, was very concerned about it and did make changes as a result of the review that we did. Another review we did, which I think has relevance to what Faisal was talking about, is we conducted a review based upon concerns that the FBI had investigated certain groups because of the exercise of the First Amendment rights. The groups that were the subject of this concern was the Thomas Merton Center, which is a self-described peace and social justice center located in Pittsburgh. People for the Ethical Treatment of Animals, Greenpeace, the Catholic Worker. The FBI had opened investigations of either individuals who were connected to these entities or the entities themselves. Our review did not find that the FBI had targeted any of them investigation on the basis of the First Amendment activities. However, we concluded that the basis for opening these reviews, the factual basis for opening some of them, was factually weak. In some cases, the FBI extended the investigations involving these advocacy groups to their members without adequate basis, and in some cases, they retained information about the groups in its files inappropriately. They also classified some of these reviews as acts of terrorism when that was a suspect classification in our review, and it resulted in some far-reaching effects, including watch listing of several of the members of these groups, so that every time that they traveled, they would be watch listed or taken for secondary screening, and we questioned that as well. And also, the FBI gave inaccurate information about the basis for some of their reviews when Congress asked about it. Again, this was a very important review that we did, and we tried to be balanced in it, not necessarily second-guessing the FBI, but showing whether they complied with the guidelines related to them and these reviews. The final report I'd like to talk about is the one, as I mentioned, national security letters. National security letters are very powerful tools. They're like an administrative subpoena where the FBI can obtain, without judicial or even Department of Justice intervention or oversight, very sensitive information about individuals based on the signature of one FBI official in the field. You can obtain, for example, transactional telephone records, email records, financial records, credit reports, car rental information, other personal data. There's a very low threshold for these national security letters. Information sought must be relevant to an investigation to protect against international terrorism or espionage, provided the investigation is not conducted solely on the basis of activities protected by the First Amendment of the Constitution. It's an important tool, and the FBI would say it's an indispensable tool in the fight against terrorism. But we found the FBI did not put in place effective internal controls to make sure that they use these important tools in accord with the laws and regulations that affected them. We also found that the use of national security letters skyrocketed after 9/11. Before September 11th attacks, there was about 8,000 national security letter requests a year. After the 9/11 attacks, after 2001, there was about 50,000 a year. And some of them contained significant abuses, we found. First of all, the FBI didn't even retain the actual national security letter. When we asked to see all of them in the files, it was scattershot. Some had been retained, some had not even been retained. Didn't even retain a copy of them in the file. The FBI didn't report accurately the number that they had asked for. Their computer databases were completely faulty, and were significantly underrepresented the number of national security letters that had been asked for. They obtained information without proper certifications or authorizations. Sometimes did not satisfy the requirements of the pertinent national security letter statute, and sometimes they asked for information on the wrong person based upon errors and typographical errors, or sometimes they got information about the wrong person and they had not even checked whose information was being returned before they put it in FBI files. Some national security letters were issued after the authorized period for the investigation had lapsed. Some they sought content information when they weren't entitled to it. Some cases they didn't even issue a national security letter to obtain the information. They just issued what was called an exigent letter, which was there's an emergency. The letter said there's an emergency and we sought a subpoena from the U.S. Attorney and we need this information in a hurry. Well, in fact, there weren't emergencies in many of the cases, and they had not sought a subpoena from the U.S. Attorney's Office. We found errors in almost 20% of the national security letter files, and that's a lot of abuse. That's a lot of abuse for an important tool like that that has significant implications for privacy rights of American individuals. We, again, made recommendations for the FBI to correct these practices. They accepted the recommendations and said they would. We are actually, the OIG, since I'm not there anymore, but I still call them we, are now in the process of doing a follow-up review to see what has happened with the corrective actions that the FBI said they would implement. We did one such review and credit the FBI for some corrective actions, but more needed to be done. So these are very important reviews, as you can see, addressing privacy issues and addressing civil liberties and civil rights issues of American citizens. And I'd like to think that we had an important effect on the FBI and the Department of Justice in ensuring that they comply with the rules and regulations that pertain to these very important powers. I believe the Office of the Inspector General can have a positive impact on an agency. It can have a deterrent effect on misconduct within an agency, and it can point out where things went wrong and how the agency can do better. The agency, as I mentioned, the agency doesn't have to follow our recommendations, but they have to respond to them. They have to say whether they agree with them, disagree, whether they'll do this or not. And often Congress will ask them, why are you not implementing this follow-up response to the OIG? Why aren't you doing this corrective action or another? And it has a way of concentrating the FBI's and the Department of Justice mind to make sure that they do take these recommendations very seriously. Now, I know that there are other mechanisms to oversee federal agencies like the Department of Justice and others. For example, there's their own internal affairs agencies that they have within the agency themselves that does some internal oversight. Congress does internal oversight and oversees the agency and will ask them to explain their actions. The press is an important oversight entity that will provide a check and balance on federal agencies. Same with outside interest groups that can provide an important check and balance. But I believe that one of the most important, if not the most important, is the Office of the Inspector General within the agency that is funded and designed to oversee an agency. It's inside the agency. It knows how the agency operates. It knows the culture of the agency. It is a very important tool to make sure the agency is complying with its requirements, its rules, its regulations, and the law. I think some of these reports that I've discussed show the value of that. But there are significant challenges in this oversight, and I'd like to address a few of them before concluding and then opening it up to discussion. One of them is access. And by law, we're required to have access to all the information in the department, but we rely on the department to give us that information. And if the department delays the information to us, it can significantly interfere with the work that we do. Sometimes it would force us to fight them tooth and nail to get the information and to get it in a timely way. It's generally good, the access we've had to the Department of Justice. Sometimes it's slow, but sometimes the slowness, we have an expression, sometimes delay is sometimes as difficult as denial of access to information. So we're constantly fighting to have timely access to the information, because without that we could not do our reports. The second thing, I mentioned this before, is transparency. I believe one of the key issues and key roles that we play is by making transparent what happens in the agency itself. And I believe the American citizen and taxpayer has a right to know what happens in the agency. It can be difficult in the area of counterterrorism and counterintelligence, because a lot of the information is classified and pertains to sources and methods, and it's difficult to release publicly. But what we try and do is push the agency to make as narrow as possible what is classified and what should be classified. And there are times when we had reports and we'd give it to the agency and say, tell us what is classified and what can't be released. And they would black out huge swatches of pages and pages and pages. And we'd say to them, why is this classified? Why will this harm the national security if it's released? And they sometimes would reduce the amount that they would classify, and then we'd say, well, tell us exactly which sentence or which words are classified and why should it be classified. And that they would reduce the amount that was classified. And then sometimes we'd look on their website and find that the same information that they were classifying in our report had been on their website. And they would reduce the amount that was classified. And then one time I remember I was told I could not say the location of a command center after the 9/11 attacks, because that would provide some information on how the FBI chooses its command centers. So in my testimony I didn't say that. I was testifying next to an FBI official, and the FBI official said, and our command center was at X site, and said exactly where it was. And I was thinking, how could it be classified in our report? And they could say it. So it's a constant battle, transparency, and I think it's important to make sure that classified information that should be classified remains classified, but it's not over-inclusive, and I think that happens regularly. Another issue that's a difficult issue is the cross-agency issues. And a lot of the issues in counterintelligence and counterterrorism has to do with how people share information and transmit information to each other among agencies. And so a lot of our work was in coordination with other IGs or even state and local entities when the Joint Terrorism Task Forces are involved as well. And that we had to do things jointly because we had oversight over the Department of Justice, but a lot of the role of the Department of Justice in the issues of counterterrorism was much more expansive than that, and therefore we had to work with others as well, and that's important, an important factor, an important challenge in the work of the Office of the Inspector General. The fourth challenge I would say is the need for follow-up. We can make recommendations, and the agency can agree with the recommendation, but then if they don't implement the recommendation, it's not really worth anything. And a lot of times they would tell us, oh yeah, we will agree and we will do this, but we would have to, we would accept that as, that makes sense, but we have to go and follow up to make sure that they actually implemented the recommendations that we had suggested and they had agreed to. And in fact, that's what the OIG is doing right now with national security letters, but we've done it with many others as well. Final thing is expertise and funding. We need to have our own expertise, and we need to be adequately funded to oversee the expansive work of the Department of Justice. And I talked about how big we were. We have about 450 employees in the Department of Justice Office of the Inspector General, but that's not nearly enough. And in fact, if you look at the growth of the Department of Justice over the last 15 years, the Department of Justice has grown by 35%. The OIG has only grown by 5%. If we grew with the same ratio as the Department of Justice, and I think that's a pretty straightforward principle, we would be at 550 rather than 450, and we would have a lot more ability to do oversight over the Department of Justice and other reviews. And I think it is important to have a well-funded internal oversight entity like the Office of the Inspector General to make sure the agency is acting appropriately. I was lucky. I received support from every Attorney General I worked with in the Department of Justice, from Janet Reno to John Ashcroft to Alberto Gonzalez to Michael Mukasey to Eric Holder. They all supported the work of the Office of the Inspector General because they realized that it added value to the Department of Justice operations, and I think that's a critical complement to the work of the Office of the Inspector General. In the end, I think it's a sound investment. A well-resourced OIG with expertise can have an important effect on the work of the agency, and I hope we did as well. So that's what that's where I'd like to end, and I'd be happy to answer any questions you have about Scott.